We have seen that under the Constitution, the Chief Election Commissioner seems to have been put on a higher pedestal when compared to other election commissioners. In terms of Chief Election Commissioner's status as the chairman of Election Commission, and also in terms of the safeguards that are provided exclusively to the Chief Election Commissioners. On the other hand, we have the law which was made by the Parliament, which treats all election commissioners and the Chief Election Commissioner on a same footing. There is no difference with respect to their salary or conditions of service or tenure. All of them are treated alike. So this ambiguity has given birth to a widely debated question. Is the status of Chief Election Commissioner higher than that of other election commissioners? So one of the first cases that dealt with this question of law was the judgment S.S. Dhanova versus Union of India, which was a judgment of the Supreme Court. So in this case, what happened was that the president had appointed Mr. Dhanova, the petitioner, and another person as the election commissioner. So there were two election commissioners in addition to the chief election commissioner who were appointed by the president. Later on, the president issued another notification abolishing the posts of the two election commissioners. So their appointment came to an end. This abolishing of their appointment was challenged before the Supreme Court. And the Supreme Court observed that while Election Commission is envisaged to be an independent institution, the power has been vested with the President to appoint as many number of election commissioners as he decides. So appointment of Chief Election Commissioner is mandatory, while the appointment of other election commissioners is only an obligatory provision. And the Supreme Court also observed that the Constitution of India purposefully accords a higher protection to Chief Election Commissioner, which is not available to other election commissioners. And the court went on to observe that election commissioners are on a higher pedestal than maybe regional commissioners. But the Chief Election Commissioner is on a higher pedestal than both the election commissioners as well as the regional election commissioners. Thus, the court clearly laid down that the Chief Election Commissioner is not a person who is the first among equals. Rather, he is deliberately put on a higher pedestal than the other election commissioners. The matter was again dealt with by the Supreme Court in the case of T.N. Sheshan versus Union of India. So, in this case, the court went on to observe that the protections that are accorded to Chief Election Commissioner did not make him superior to the other election commissioners. Those are protections that are given to Chief Election Commissioner because he is a permanent incumbent. The other election commissioners, they, as we have already seen, are appointed by the president as and when he deems it necessary. It is not a permanent office. On the other hand, the post of the Chief Election Commissioner is a permanent office. It's a permanent body. So the court reasoned that the safeguards regarding irremovability from the office was not given to election commissioners because their office is not permanent in nature. Their office is such that they cannot be conferred with the position of irremovability. Their process of removal cannot be made tougher by equating that removal process to that of the removal process of a Supreme Court judge. So the court held that the higher status, the seemingly higher status that is conferred on a Chief Election Commissioner is because of because of the fact that his office is a permanent office and the office of election commissioners is not a permanent office. The court also went on to observe that even though they were not given status equivalent to that of Chief Election Commissioner, the constitution makers did provide the election commissioners also with some sort of independence and security of tenure by placing their removal subject to the recommendation of Chief Election Commissioner. So this was how the court settled the matter. So the Supreme Court settled that there is no higher status that is accorded to Chief Election Commissioner and that both are to be treated at par. Very recently, a constitution bench of the Supreme Court pronounced a judgment called Anup Baranwal versus Union of India. This has the potential to transform the way in which Election Commission of India operates. Why is this so? If you will look into Article 324 Clause 2 of the Constitution of India, you will see that it provides that the appointment of Chief Election Commissioner and other election commissioners shall be determined by the President until the Parliament makes a law on that behalf. So the aspect of determining how to appoint election commissioners, including Chief Election Commissioner, has been left to the Parliament by the constitution makers. It's just that the Parliament has not made a law till date. Now, we have already seen another legislation which was brought out by the Parliament for regulating the conditions of service of election commissioners. But this legislation does not deal with the matter of appointment of election commissioners, which the Parliament is empowered to do. So what the court said in this case is that because Parliament has not made a law governing the appointment of Chief Election Commissioner and other election commissioners, we will step in and make a law. Now, this is not a new phenomenon. You might have all heard about the Vishaga judgment, where the Supreme Court stepped in because there was a legislative vacuum. There was no rules or laws to prevent sexual harassment in workplace. So what did the Supreme Court do then? The court formulated a set of guidelines until Parliament made a law on their behalf. So it is the same principle which is being applied here. Since Parliament has not yet made a law, the court felt that it should step in to make a law governing the appointment of Chief Election Commissioner and other election commissioners. So what the court stated in this case was that for the appointment of election commissioners and the Chief Election Commissioner, a committee needs to be constituted. And this committee should consist of the Prime Minister, the Leader of Opposition in the Lok Sabha, and the Chief Justice of India. So you will see that this committee comprises of a representative in the Parliament, an executive member, and a member of the judiciary. And it is based on the recommendations of this committee that the appointment of election commissioners and Chief Election Commissioner has to be finalized. Another rule that was made by the court in its judgment is that the conditions of service of election commissioners should also not be varied to their disadvantage once they have been appointed. If you will recall, this was a safeguard that was applied solely for the Chief Election Commissioner under the Constitution. So now the Supreme Court's judgment extended this safeguard to the other election commissioners as well. But the court did not rule that the grounds of removal of election commissioners should also be similar to that of Chief Election Commissioner. The court merely said that it is desirable if the grounds of removal of election commissioners are also similar to that of Chief Election Commissioner, which is equated to that of a judge of a Supreme Court, if you will remember. So once again, the appointment was made subject to the recommendations of a committee comprising of Prime Minister, Leader of Opposition in the Lok Sabha, and the Chief Justice of India. The conditions of service of election commissioners was equated to that of Chief Election Commissioners, inasmuch as the conditions of service cannot be varied to disadvantage after appointment. But the court merely recommended that the grounds of removal of election commissioners should also be equated to that of Chief Election Commissioner. Now, obviously, the court's recommendation is based on the fact that Article 324 Clause 2 reveals an expectation that Parliament would pass a law providing for the mechanism of appointment of Chief Election Commissioner. So in its absence, the court was stepping in to fill the vacuum. And the suggestion of involving members of the Parliament, Executive and Judiciary is not something new. The court did not come up with that suggestion on its own. Rather, they were following the suggestion that was mooted by various committees that were constituted for looking into the possibilities of reforming election commission. Various committees and commissions have been constituted. So the court took up the suggestions, this as a suggestion from various commission and committee reports that had put forward this idea. Now, I want to leave you with this question. What do you think about this new rule that has been made by the Supreme Court? Does it compromise on the aspect of independence of Election Commission of India, particularly because the Prime Minister, who is a member of the executive, is involved? This is a question that I want you to ponder upon and reflect. Now let us try to understand the administrative machinery for elections. We have the Election Commission of India, which is the nodal body when it comes to governing election matters in the country. But there are also a lot of government officers who take care of the administrative matters surrounding election. One such officer is the Chief Electoral Officer. This is the officer who supervises the election work of an entire state or an entire union territory. We also have a similar officer for each district. This is called the District Election Officer, who supervises the election work of an entire district. So we have a Chief Electoral Officer and a District Election Officer. Then we have someone called an Electoral Registration Officer. This is the officer who prepares the electoral rolls for each and every parliamentary constituency as well as state assembly constituency. At another level of the hierarchy is the people called booth level officers. So these are officers who are functioning with the local government. These may be officers who are otherwise employed with the state government or the local government. So these people will also be the voters of the particular area of which they are a booth level officer. So there may be a constituency of which they are a voter, and they may also act as the booth level officer. Now, these booth level officers have a very critical role to play. Since they are the particular localites of that area, they might be in a position to understand what all changes have happened in that constituency, who all have left that constituency, who all have migrated, who all have passed away in that particular year. So this will help the election workers to update the electoral rolls. As you all know, once you have your name in the voters list, only then you are eligible to vote. So booth level officers go from door to door in their particular constituency, and they ensure that the voters list gets updated by removing the names of the people who have left the place and by adding the names of the people who have recently joined. So this is an overview of the administrative machinery for elections. In addition to these officers, we also have another set of officers called the returning officers, the presiding officers, and the observers. These three set of officers are appointed under the Representation of People's Act of 1951. So let us look into what a returning officer is. So the returning officers are appointed by the Election Commission for a particular general election in each state. And the returning officer will be generally an officer of the government or of a local authority. And one returning officer can be nominated for more than one constituencies in a particular state. There are also some officers who are appointed who are called assistant returning officers, who will assist the returning officers in conducting the elections. Now, the duties of the returning officers are not explicitly mentioned in the Representation of People's Act. It has just been stated that the returning officers are expected to do all such acts that are necessary for an effective conducting of the elections. But in practical reality, the returning officer performs duties like accepting and scrutinizing nominations, the publishing of the affidavits of the candidates, the allotting of symbols to each election parties, preparing the electronic voting machines and the VVPATs, even the counting of votes and the declaration of results. In all of these activities, the returning officer has a very crucial role to play. Now, interestingly, the returning officers are called so because they hold the elections and return the results of an election. That is why they are called the returning officers. I hope that is clear now. We also have another set of officers called the presiding officers. So these are also officers who are appointed by the Election Commission, but these are officers who are appointed on deputation. So their deputation gets over when that particular election also gets over. and their duty is to keep the polling station in order and to ensure that the polls are being conducted fairly. Now, you must not confuse presiding officers with that of polling officers. Now, polling officers are those officers who are usually government servants who are appointed just for the purpose of that particular election. These may be teachers in a government school. These may be officers of a public sector undertaking. So these polling officers, they are the ones who mark that indelible ink on your finger when you go to a polling station to cast a vote. Those are the polling officers. They will assist the presiding officers. The presiding officer will ensure that the elections are being conducted fairly. Their duty, as the name itself hints, is to preside over the polling station and ensure that everything is being conducted in a fair manner. The last set of category of officers that we need to understand are called observers. Now, there are two kinds of observers in every election. You might see people belonging to or maybe affiliated to a particular political party sitting in one corner of the polling station to ensure that there is no malpractice, to ensure that there is no one political party trying to influence the voters, etc. So there will be representatives of each political party in one corner of the presiding of the polling station. But the observers are not those people. Observers are the officers of the government of India itself who are present in each polling station in each constituency to ensure that the elections are being conducted in a smooth manner. Now, observers, what makes them different is that they have a power that none of the other officers have. The observers can direct the returning officer to stop the counting of the votes or to not declare the results after the votes have been counted. They can do this or they can exercise this power if they feel that some untoward event like a booth capturing or some illegal malpractice is being conducted in a polling station, or maybe some of the electronic votes have been tampered with or destroyed. In such case of exigencies, the observers can direct the returning officers to stop counting the votes and to stop declaring the results. I hope you have understood the administrative machinery of elections. So far, we looked into the composition of election commission, the administrative machinery behind running of the elections in a smooth manner, etc. But have you really understood what are the functions and powers of Election Commission of India? Of course, we saw that the Constitution prescribes that the Election Commission is to ensure superintendence, direction, and control of the preparation of electoral rolls. But what does this mean exactly? What does superintendence, direction, and control of preparation of electoral rolls mean? For that, we need to look into this legislation called the Representation of People's Act of 1951. It is this legislation which provides a clarity on the scope and ambit of Election Commission's powers. There are a different variety of functions for the Election Commission of India under the Representation of People's Act. This starts from the Election Commission of India's mandate to notify the dates for elections. As you will recall, the Election Commission conducts elections to 4 offices: Parliament, State Legislative Assembly, President and Vice President. So for all of these 4 elections, the Election Commission of India has to notify the dates on which the elections are to be held. The next function is that the Election Commission has to direct as well as approve the polling stations of each constituency in each state. So this is also something that the Election Commission has a prerogative on. Now, in every election, there is a nomination of candidature, and after that, the returning officer scrutinizes the nominations to see that everything is intact and no laws are being violated. So after the scrutiny of nominations, only then the candidature is accepted or rejected. Even after that, even after the candidature of a particular candidate has been accepted by the returning officer, the candidate can withdraw himself from elections. So for all of these, there are certain last dates beyond which you can't do any of these activities. So there is a last date for filing nominations as a candidate of a political party for contesting the elections. There is a last date by which the scrutiny of nominations has to be completed. There is also a last date beyond which you can't withdraw your candidature. So all of these last dates are being fixed by the Election Commission. It is the Election Commission which also fixes the date and time on which the elections will be completed and the results will be declared. So all of these are decided by the Election Commission of India. The Election Commission also fixes the number of hours within which the entire polling process should be complete. So if you have gone for voting in some of the elections, you might have noticed that there will be a provision of time, say from 6 a.m. to 6 p.m., beyond which you can't cast your vote. So the number of hours within which you need to cast your vote, that is also fixed by the Election Commission. Now, in certain circumstances, there may be a need to adjourn the poll to a later date. Say, if there is a natural calamity in a particular state, or if there is a major accident, or if there is a riot which is happening within the state. All of these are unforeseen situations or unexpected events in which you can't conduct an entire process of election in a very peaceful manner. So in such situations, what does the Election Commission do? They take a call on whether to conduct elections in that state at that particular point of time or to adjourn it or postpone it to a later date. But in certain situations, there might be no option but to cancel the elections. In legal terms, we call it declaring the elections void. So this will render that entire process of elections as having the effect of being cancelled. So this might happen in situations where booth capturing takes place. What is booth capturing? It is a situation where there are people inside the polling station and they ask or influence the voters to vote for a particular party, maybe by force, maybe by coercion, maybe by threatening. So this is what booth capturing is. So in situations of booth capturing, or maybe if they have reason to believe that the electoral votes have been tampered with or destroyed, either intentionally or accidentally. In such situations, you can't adjourn the polls, but you will have to declare the elections void and you will have to call for a fresh elections in that particular constituency. So it is the ECI or the Election Commission which takes a call on this and declares an election void and calls for fresh polls. Now, as we already saw, the entire administrative machinery for elections, that is supervised by and directed by and within the control of the Election Commission of India. So they have to supervise the Chief Electoral Officer, who will in turn supervise the other people who come within the hierarchy. So Election Commission has the overall responsibility to supervise the entire administrative machinery. And it is the Election Commission which designates other key personnel such as the returning officers, the presiding officers, the polling officers, and the observers in each particular constituency. So the entire administrative machinery of elections runs under the control and direction of the Election Commission of India. Lastly, under the Representation of People's Act, there is this concept of registration of political parties. Now, there are certain benefits that come from registering with the Election Commission of India as a political party. This might be with respect to getting symbols allocated to them, getting a particular name allocated to them. So these are certain prerogatives that are there for political parties if they register. And registration is mandatory for recognition of a political party as a national party or as a state party. So for this, it is the political parties who register themselves with the Election Commission of India. So this is a broad overview of the various functions that are performed by the Election Commission of India as envisaged under the Representation of People's Act of 1951. Did you know that airwaves are considered as a public property? So there is a Supreme Court judgment called the Secretary, Ministry of Information and Broadcasting versus Cricket Association of Bengal. This is a landmark judgment which ruled that airwaves are to be considered as a public property. What does this mean? This means that all citizens have a right to access and use airwaves in an equitable manner. And we all know that airwaves are most frequently used in TV as well as radio. Now, you might have seen different political parties trying to spread out their message to their voters through television programs and radio programs. So, since airwaves are a public property, the Representation of People's Act has created a mechanism whereby it has conferred on the Election Commission of India a responsibility to ensure that airwaves or the spectrum is distributed amongst all political parties in an equitable manner. How is this happening? So, the Election Commission of India will assign certain broadcast time on the government-owned media such as Doordarshan or All India Radio. So, within this broadcast time, each political party can do their election campaign through TV or All India Radio. And how is this done? So, a base time of 45 minutes is given to each political party. And mind you, this is just applicable for the government-owned media, that is Doordarshan and All India Radio. And this is an option that is available only for the parties which are recognized as national parties or state parties. So, base time of 45 minutes is allocated to all political parties. And if at all an additional time is given to a political party, it will be based on their past electoral performance. So, if a political party, say A, has won in the election in the past year, then they will be given an additional time, say, which is different from a party which did not win the elections. So, the additional time is allocated based on the previous electoral performance. And you all know that there are certain slots in TV as well as in radio which are considered as prime time. So this is the time gap within which there will be maximum number of viewers listening to the programs or viewing the programs. So this prime time slot may be from 8 to 9 or from 7 to 8, depending on which is the time slot which is garnering more number of viewers. So to ensure that no one political party gets the advantage of doing their election campaign during the prime time slot, the time slots themselves are distributed to each of the political parties through a lottery system. So lots are picked for each political party to understand within which time they should do their election campaign. So this will ensure that no preferential treatment is given for one political party for the prime time slot. Now, before these programs are being aired on TV or on radio, the transcripts of that program will be reviewed and vetted to ensure that they do not violate any of the laws and regulations. We'll understand what the laws and regulations when we look into the Model Code of Conduct. So there is something called Model Code of Conduct which lays down certain do's and don'ts that each political party has to abide by, each candidate has to abide by once the elections have been declared. So these transcripts are vetted in order to ensure that they don't violate any of the conditions that are prescribed under the Model Code of Conduct or any other laws and regulations that are in place. And there may be a case that a political party will say that, say, you have unreasonably asked me to restrict my speech, you have unreasonably asked me to delete a portion of my speech, etc. So in order to settle such disputes that might arise after the transcripts are reviewed and vetted, an apex committee will be constituted. So this apex committee will comprise of members from Akashvani and from Doordarshan, and they will decide the disputes that are arising out of the review and vetting of the transcripts. So once this apex committee decides, that will be final and there can be no further deliberations on it. So this is how airwaves are distributed equitably amongst all political parties once elections have been declared. So this is also one additional function or prerogative that the Election Commission of India has by virtue of the Representation of People's Act 1951. Now let us understand what this Model Code of Conduct is. As I said before, it's a list of do's and don'ts that each candidate and his political party is required to abide by before elections. And if they do not observe the guidelines that are mentioned in the Model Code of Conduct, the Election Commission can take an action against them, which may even result in them losing out on their opportunity to become a representative. So it's a very serious guidelines. Even though it's termed guidelines, it's a very serious guidelines. This has to be complied with without any dilutions. So the first set of guidelines under the Model Code of Conduct is regarding the general conduct of the political parties and their candidates. So first of all, you can't indulge in any activity which is likely to cause communal tensions or tensions amongst different people owing to their religious background or caste background or gender background. So you can't flare up those existing differences by your election campaigns. Secondly, even if you criticize your political opponents, it should be strictly regarding the work of those political opponents in the public domain. You can't criticize them for their private activities or their private life. And you also can't lodge unverified allegations that may result in a grossly distorted picture of that particular candidate or party in the public domain. As part of general conduct, you also cannot appeal to different voters based on the language or caste or religion. Such considerations, you can't ask for vote directly or explicitly based on such considerations. And you also can't use places of worship for your election campaigns. Say you can't conduct an election campaign in front of your mosque or temple or church. These activities are strictly prohibited. You might also know that there might be instances where the parties or candidates may indulge in corrupt practices like intimidating voters to vote for their particular party or to bribe their voters to vote for them. So these are also activities that are prohibited under the Model Code of Conduct. Under the general conduct, there's also one more aspect that is mentioned, which is that you can't organize picketing activities or demonstrations in front of people as a mark of protest. You have to respect the private life of all the voters of your constituency. So if you know that a particular voter is not likely to vote for your party or your candidate, you can't go and sit in front of their houses and launch a dharna or a demonstration as a mark of protest. This is also something that is clearly prohibited under the Model Code of Conduct. Now let us look into the second set of guidelines, which is regarding the meetings of these political parties. So whenever a political party or a candidate is holding a meeting, they have to inform the police well in advance so that necessary arrangements can be made for controlling the traffic and maintaining the law and order. They also have to seek necessary permissions if at all they want to use things like loudspeakers for their election campaigns. For all of these, there are licenses or permissions that are required. All of these have to be secured well in advance before the political parties or the candidates conduct meeting in the open public domain. You might have also seen processions happening as part of election campaigns. These are called by various names in your district. So it might be an election rally, it might be an election campaign, it might be a road show. So in all of such processions, there are certain guidelines that have to be followed. Again, the time, place, venue, everything has to be notified to the police well in advance so that they can ensure the necessary arrangements. And if it's going to be a long procession, they have to bifurcate into segments so that after each segment is over, the police can release the traffic that they have been holding. So this will ensure that the election campaign will also happen and the public's life and the right to move will not be curtailed in a restrictive manner. So this is also something that has been mentioned under the Model Code of Conduct. Now on the polling day, the candidates and the political parties have to cooperate with the Election Commission's officers to ensure that the polling happens in a very smooth manner. Now, the Model Code of Conduct also explicitly states that you can't you can't exhibit any flag of your political party or any symbol or poster on the polling station. It's only the candidate's name will have to be written in the polling station. You might have seen all the political parties exhibiting their candidate's name. Only that is permitted. You can't put any election campaign material such as poster, flag or election symbol in front of the polling station. Another aspect in the Model Code of Conduct is certain guidelines that are exclusively there for the political party that is in power at the time of elections. So when a party is in power, they will have access to a lot of government resources, right? But the Model Code of Conduct clearly says that you can't use government resources for your campaigning or for your advantage, for putting your political party in a position of advantage. So the government resources cannot be utilized. There are also certain other guidelines. Say you can't issue advertisements with the money that is drawn from the public exchequer. You also can't do certain activities once elections have been declared. So you can't lay foundation stones in any particular building or in any particular locality. This is something that the political party in power is usually prone to doing, right? Because they hold the positions of responsibility. So once the elections have been declared, you can't lay foundation stones and you can't make promises for providing public utilities. Say you can't make promises such as, I will guarantee you this much job, I will guarantee that this facility is brought into existence in your constituency, etc. As long as it's a public utility, you can't make such promises once elections have been declared. And you also can't engage in ad hoc appointments. So this sort of restriction comes into play in a particular time period that is fixed by the Election Commission. Usually it is the 2 weeks preceding the date of election. It is at that point of time when such sort of restrictions will come into play. So when all of these restrictions are in place is decided by the Election Commission of India.